Hey there, amazing people. I'm thrilled to have you here today. Welcome to our video on Article 4 of the European Convention on Human Rights. We're thrilled to have you here. Article 4 of the European Convention on Human Rights prohibits slavery and forced labor, conscription, national service, prison labor, service exacted in cases of emergency or calamity, and normal civic obligations are accepted from these definitions. Let's now shift gears and explore background through a critical lens, uncovering its strengths and weaknesses. Article 4 is an absolute right, which means it cannot be restricted. There is an absolute prohibition on slavery and servitude under Section 1, with no scope for derogation. Article clarifies that there is no derogation from Article, even in time of war or other public emergency threatening the life of the nation. However, there is a more limited prohibition on forced labor, with exceptions clearly defined with Section 3 of the article. Article 4 also imposes a positive obligation on states to actively ensure that there is no violation of the prohibition on slavery and forced labor. This is opposed to a negative obligation where states must simply refrain violating fundamental human rights. The ECFA confirmed in Civic v. France that Article 4 imposes a positive obligation on states to adopt criminal law provisions in relation to the prohibition. Therefore, states are required to criminalize slavery, servitude, and forced labor. Welcome to the next segment, where we explore slavery and servitude art and its significance in our journey. Slavery and servitude art. There is no definition of slavery or servitude within the ECHR. Brace yourself for a captivating discussion on slavery as we explore its nuances and implications. The ECFA have adopted the definition of slavery from Article 1 of the Slavery Convention 1926, which states that slavery is the status or condition of a person over whom any or all of the powers attaching to the right of ownership are exercised. This was clarified by the ECFA in Civic v. France. The case of Dog of the Ukraine confirmed that the condition of slavery is not satisfied simply by work without payment. Get ready for a thought-provoking discussion as we delve into servitude and its impact on our understanding. The Commission of Human Rights stated in Van Drugenbroek v. Belgium that servitude involves an obligation that is placed on an individual to provide work as well as a violation of freedom. The violation of freedom must involve the individual being forced to live on another's property. Civic v. France also confirmed that there must be an element of coercion. The ECFA explained the distinction between slavery and servitude in Civic. They stated that a particular serious form of denial of freedom was needed to constitute servitude, which could amount to the complete restriction of freedom of movement on the victim. In the next portion, we'll be immersing ourselves in the realm of forced or compulsory labor art and examining its broader implications. Forced or compulsory labor art. There is no definition of forced or compulsory labor in the ECHR. The concept of forced labor was set out in Van der Mussel v. Belgium, where the ECFA adopted the definition from the International Labour Organization Convention of 1930, or work or service which is exacted from any person under the menace of any penalty and for which he has not offered himself voluntarily. The ECFA confirmed that there must be physical or mental constraint as well as involuntarance, injustice, oppression or avoidable hardship in order to constitute forced labor. There is no explicit test for forced labor, but the ECFA stated in Mussel that a range of circumstances will be considered, and the facts of the case will determine whether a particular service falls within the prohibition of forced or compulsory labor. Iverson v. Norway held that the obligation on the individual to work must be excessive and disproportionate in order for the service to constitute forced labor. Without further ado, let's move on to the topic of exclusions art. Exclusions art. Section 3 of Article 4 ECHR provides for circumstances in which forced or compulsory labor under Section 2 do not apply. The exclusions apply to those in detention prisoners, compulsory military service, the emergency services and any work which constitutes normal civic obligations. CN and VV France interpreted the exclusions under Article to also suggest guidance on what shall not constitute forced labor under Article. These exclusions are justified by the idea of the general public interest. The ECFA stated in Schmidt v. Germany that the exclusions are based on what is normal in the ordinary course of affairs. In the upcoming section, we'll be shining a light on work done in the ordinary course of detention. Prisoners, or those on conditional release, often undertake unpaid work during the course of their detention. Compulsory work in a forced labor institution would not violate Article if carried out by prisoners as part of their rehabilitation. The ECF emphasized in De Wild, Humes and Verset v. Belgium the relevance of the compulsory work forming part of rehabilitation as well as being compatible with the general norms of work in detention within the relevant member state. As we transition, let's shed light on military service and its relevance to our ongoing exploration. Both voluntary and compulsory military service would not constitute a violation of Article. This is applicable to conscription and national service. There is no right to conscientiously object to military service under Article 4. This was clarified in Grand Draft v. Germany. This case held that it is up to each member state whether they wish to grant the right of conscientious objection and that substitute civilian service can be imposed on objectors instead, which they have no right to object to. Let's now enter the realm of emergency service and discover the fascinating stories it has to tell. Compulsory demands placed upon individuals in the case of emergency or calamity threatening the life or well-being of the community will not constitute a violation of Article, so long as they are proportionate. In Iverson v. Norway, the ECFA stated that a law requiring dentists to provide public dental services was not in violation of Article 4 due to the public nature of the case. As the work was of short duration and was well paid, the ECFA stated that the prohibition on forced labor could not reasonably be interpreted to apply. Get ready for a captivating exploration as we unravel the layers of normal civic obligations and their profound significance. Any compulsory work which constitutes a civic obligation will not amount to a violation of Article. A civic obligation has been interpreted by the ECFA in many different ways and is dependent upon the circumstances and context of each case. In Odomi v. Malta, the complainant argued that it was a violation of Article to require him to participate in jury service as he had been called upon 3 times during the period of 1971 to 1997. The ECFA considered that jury service was a normal civic obligation and therefore did not constitute forced labor or a violation of Article 4. With the foundation laid, let's embark on a journey into human trafficking. The definition of human trafficking can be found in the Council of Europe Trafficking Convention. Human trafficking is not explicitly mentioned within Article 4. However, following the case Ransom v. Cyprus, it was confirmed by the ECFA that human trafficking fell within the scope of Article 4. Within this case, the ECFA set out the nature and the scope of the positive obligation placed upon states under Article 4 in relation to human trafficking. Modern slavery is often associated with trafficking victims from abroad who can be forced into circumstances such as manual labor or sex work. The case SM v. Croatia established that forced prostitution as a result of human trafficking is covered by Article 4. This case saw the first Grand Chamber judgment concerning human trafficking and found that Croatia had not fulfilled their obligations under Article 4 by failing to fully investigate potential human trafficking. This was the first time that internal human trafficking had been considered as relevant under Article 4 and is therefore significant in expanding its application. SM disregarded any ambiguity that was created following Ransom by clarifying that human trafficking and forced prostitution fell within the scope of Article 4. Within SM v. Croatia, the Grand Chamber reiterated the 3 positive obligations that Article 4 places upon states that were set out in Ransom. 1. The duty to put in place a legislative and administrative framework to prohibit and punish trafficking. 2. The duty, in certain circumstances, to take operational measures to protect victims, or potential victims, of trafficking, and 3. A procedural obligation to investigate situations of potential trafficking. As we venture forward, let's take a closer look at violations found by the European Court of Human Rights and its impact on our understanding. Civic v. France, Application No. Adjudicated in 2005, case of servitude and forced or compulsory labor Ransom v. Cyprus and Russia, Application No. Adjudicated in 2010, case of human trafficking Celsius, North, and v. France, Application No. Adjudicated in 2012, Celsius, North, v. the United Kingdom, Application No. Adjudicated in 2012, Cheetos v. Greece, Application No. Adjudicated in 2015, L. East v. Greece, Application No. Adjudicated in 2016, Chaudhry and others v. Greece, Application No. Adjudicated in 2017, South M v. Croatia, Application No. Adjudicated in 2018, TI and others v. Greece, Application No. Adjudicated in 2019. As we progress through this video, let's shift our attention towards history and uncover its hidden depths. R.B. Knowles, ex parte Somerset, 1772. Slavery at Common Law, 13th Amendment to the United States Constitution. Your feedback helps me improve, so please take a moment to leave a comment or review.